Okay. So good afternoon, everybody. Many thanks for joining us for the second of our Preparing for Brexit webinars. I'm Hannah Vickers, the Chief Executive of the Association for Consultancy and Engineering, and I'm with you today, whether you're a member of ACA, CECA, or all very welcome. We decided to put these webinars together to help you navigate the issues around Brexit, and we hope to provide clear and tangible advice, free from political noise and hot air that sometimes surrounds this debate. I'd like to welcome our panel today, who have very kindly given up their time so they can be here with us. So thank you all. Before I introduce them individually and we kick off, I'd like to set out some quick housekeeping rules for you. So we're aiming to be on for around an hour today. This will be recorded so that people are able to listen again or share and catch up. We'd recommend, if you are listening in, to listen on headphones and ensure your microphone is turned off so that everything is clear coming through to you. And also that there's an opportunity to ask questions at the end of the session. So we will hear from each of our four panelists, and then you'll be able to put your direct questions to them. So please, as we're listening today, make sure to your questions under the questions section in your GoToWebinar control panel, and then send privately. So you can do that at any point during the webinar, and what we will do is collect them up at the end and put them to our panel. Any that we don't get through, we will do afterwards and add to our accumulating frequently asked questions document, so you will get an answer whether or not we get time to get to you today. So please do make sure you make the most of that if you have a specific query. So, before we get started, let me introduce the panel. Firstly, we've got for a second webinar from Geoffrey Spence. So Geoffrey is closely linked with ACAs. He's one of our advisory board members, but he also has extensive experience being a former SPAD to Alistair Darling at the time of the banking crisis, and then following that working within Infrastructure UK in the Treasury, and also as head of infrastructure for Lloyds Bank. So a wealth of experience we can draw on there with Geoffrey. Siobhan Adams, who is a Global Customs and Trade Counsel at the Delphi Technology, and she'll be taking questions and updating us a little bit on World Trade Organization rules and what that might mean in the event of a no-deal Brexit. And Buckby, who is a partner at our ACE legal affiliate, Beale Co, and he's going to be discussing contractual queries and contractual questions around what that might mean going forward. And finally, by no means least, a second returner, our very own Julian Francis, who is Director of Policy and External Affairs at ACE. And he's going to start by kicking us off with a bit of an update on the political situation, just to bring us up to speed on what Tuesday's events in Westminster actually meant for Brexit. So Julian, over to you.
Thank you, Hannah. Well, certainly since we last met, the maxim that Harold Wilson stated that a week is a long time in politics is absolutely true. We've seen quite a bit of movement. We must remember that the last time we were here discussing this, the government had faced the largest defeat of any government in pretty much history over its European policy, and yet it has now sort of emerged with a route forward, much to the surprise of, I think, the commentary classes and even people within inside Westminster. But when we look at it, we have to see that it is somewhat a qualified success for the government. And it is a message that Brussels itself is, I think, probably looking at and trying to figure out what exactly it means, because the Prime Minister's victories are not overwhelming. They're not of the that she suffered the last time this was looked at, but are important in showing that she was able to hold the line and come up with ideas. So essentially, a majority of the House of Commons decided not to delay the Brexit process, to continue to have it in the government's hands, not take it back into the House of Commons. That was, in some cases, very important. I think people looked into the abyss the last time and recognized that the House of Commons itself is probably not the best arbiter of determining the timeframes for Brexit, but it recognises it has an important role at holding the government to account. Secondly, they voted that the preferred option was to leave with a deal. It was a small majority on this one, but there was definitely a majority of people who said actually their preferred option is to leave with a deal, not to crash out with no deal option. And then the third victory is the government agreed to an amendment delivered by a very senior Conservative backbencher, Sir Graham Brady, who's chair of the 1922 committee, which essentially is the Conservative Party's backbench organisation, that recognised that some modifications to the Irish backstop, some time limits and so on, would be the preferred option. So essentially what we now see is the House of Commons has said that they want a deal. They're happy broadly with the deal that has been struck with the European Union at this time, but are concerned about essentially that Irish backstop, which we keep hearing about. And if there can be some flexibility and movement within that, some imaginative use of language or thoughts around, and the indications are that we could well see this deal coming together. The question now, of course, is what will the European Union do within this one? And although we have been very much focused on Westminster, I think some of the reports coming out of Dublin have been extremely interesting on this one. We have seen the Irish government question what the backstop actually means. Ireland has woken up to the fact that if Britain crashes out without a deal, then something's going to happen in Northern Ireland, whether they like it or not. And so the Irish government has been at pains to deny that a hard border will actually develop if there is no deal. But the European Union hasn't been quite so sanguine about this. When questioned, EU officials stated that if Britain did crash out with no deal, then absolutely there would be a hard border in Ireland. And the Irish government then responded in a bit of panic. This led to statements that the Irish government would not build new infrastructure on the Irish border, would not seek to enforce tariffs and duties, and that led to a response from Brussels, from Michel Barnier himself, saying no, when we meant it, we weren't talking about a hard border as a traditional border. We were looking at it as a way of intelligent policing and using of technology to monitor that border. We don't see any new infrastructure going up. Well, that surprisingly sounds like we're arguing as the options that could be used for the Irish border. So have we seen a little bit of movement here? Quite possibly. We may be getting to a point where some kind of agreement can actually be reached on the Irish border. But for now, everyone is keeping their cards very much close to their chests.
And just if we're looking forward for the next couple of weeks, can you just talk us through the process around how might we see this resolve? Say, what are the milestones that we should look out for in the coming weeks before we get back, perhaps on our next Brexit webinar?
The milestones obviously are going to be things that people aren't necessarily going to see. There's going to be a lot of toing and froing in diplomatic circles. The Prime Minister is going to be reaching out to her colleagues in other national capitals around Europe. You're going to see the DEXU team in Brussels talking to their opposite numbers, finding out what appetite there is to actually address this. Europe's going to want to know very specifically what Britain is looking for. It's going to be very concerned about any attempts to reopen the agreement, because if you start doing that, perhaps other worms will start coming out. They'll want to know what they actually have to give, what is the cost, and they will also be very keen to know that the Prime Minister can deliver. Dublin itself will also be wanting greater certainty over this. And domestically, the Prime Minister is going to be trying to find allies. She did manage to win those votes, but not because of all of her own. She managed to a number of opposition, particularly Labour MPs. And so you can imagine the whips are going to be trying to figure out who's biddable within the House, who can they actually build and bring into this coalition, so that the Prime Minister can hopefully show the Europeans that it's not just her own party in the DUP, but some of the opposition as well, which gives her a much larger majority. Then eventually, the inevitable trip of the Prime Minister to Brussels. We will all be watching that with interest. There will be mood, music, and body language that people will assess around that, and then they will come back. What we do know is that the Prime Minister is hoping to be back by the 13th of February to the House of Commons, and that's the next milestone. We do have a few issues. Europe will want to take this to the brink. They tend to. Angela Merkel has already stated that people need to stare into the abyss before they'll be ready to make a deal. So this can go down to the wire. But Europe also has to remember that any agreement has to pass the European Parliament, and it will need time to do that. Into a bizarre situation where the EU asking for an extension itself in order to make sure that it meets its requirements to get it to the European Parliament.
Great. So next instalment on the 13th of February, and we will keep watching as to what happens ahead of that. So Geoffrey, I'd like to bring you in here. Obviously, you've worked at the highest levels of government. So what is your view in terms of the events of the last couple of weeks? What would it mean for government, for the civil service? What are the likely things that they will be looking at and focusing on during this period until we, as I said, perhaps know a little bit more around the 13th of February?
Well, in some respects, what's happening and what has happened isn't such a surprise, in that as you move to a given deadline in any negotiation, and we have two negotiations going on here. We have a negotiation in Parliament and within the UK executive as to what happens next. And then we have a diplomatic negotiation with the EU. Actually, I would say we've got two diplomatic negotiations now going forward. One with the EU collectively, and one I'd say with the Republic of Ireland in terms of what their position is as we head towards the end game. And I think basically what we've seen in the House of Commons is everyone wanted to keep open the best outcome from their point of their group right up until the last minute. And it's entirely possible when you get to the last minute that some people will finally change their minds. So, for example, if you're a keen Brexiter and you want that to happen, but there isn't a majority in the House of Commons at the very last moment for withdrawal from the EU without an agreement, you might at that point in time jump for Theresa May's old agreement and the old withdrawal agreement rather than any new withdrawal agreement that she gets. So I think your calculations in this as a politician are always to seek to get the maximum outcome and then probably any compromise towards the end of the process. And that's true for negotiation as well. So what I see is actually a lot of people behaving in some respects quite rationally, given their point of view in Parliament, given the fact we're still in negotiation, I believe, with Europe and with the Republic of Ireland. But that does mean that probably you'll not really see everyone's final play in that until we really are, at 11 p.m. before midnight, or possibly 3 a.m. in the morning and afterwards.
Okay, so that's a sort of hold your nerve insight there from Geoffrey. Thank you. So what do you make then of what business is doing? We've seen, increasingly vocal protestations from the manufacturing, car manufacturers and the sort of aerospace industry around, we cannot have no deal, being very, very vocal about it. Do you think that's actually likely to sway anything, or do you think it is a case of we're just going to have to wait and plan for it?
So, business is a participant in this negotiation, and they don't want a deal, and it's the right time for those major companies who feel that they would be damaged by a no-deal scenario to stand up and say so, and try and influence what happens in the House of Commons. I think for business, what they say, the interesting thing is, I remember about 10 years ago, we were all sitting around a table saying, well, basically the world is being run by businesses. They're actually pulling all the political strings. I'll have to say, I don't hear that anymore. And the reason is, I think over the last 10 years, what we've seen is they don't. And when it comes to these decisions, actually, they don't have a vote. And one of the reasons they don't have a vote is they're not, corporates don't get a vote at elections. And these politicians know that. And while they're concerned, many of them, from a different perspective on what happens to the economy, they are there to represent the people who voted them in their constituencies. And frankly, I think the chairman of various constituency parties, in terms of the Conservatives, will probably have far more say than the CEO of Airbus as to what happens next. So I think that's what businesses are trying to do is influence the debate, and that, from whatever side they come from, that's the right thing for them to do. But I wouldn't regard the business vote as being the most crucial as these weeks unfold. So what businesses are doing is in advance of potential trouble, warning people that there could be problems if things don't go right. And what businesses are also doing is actually putting in place arrangements to make sure that they can weather the storm if there is a storm.
Excellent, thank you, Geoffrey. Really useful insight there. So just a quick reminder that you can send your questions in, so please continue to do that, and we will come to them towards the end of the webinar. So on to what it actually might mean if we are looking to trade in a sort of no deal scenario. And I think this is relevant regardless of whether we have no deal Brexit or actually whether we migrate to different sorts of trading arrangements with the rest of the world in future. So on that basis, it would do us all well to learn a little bit more about what it actually means to trade on WTO terms. So Siobhan, if I could bring you in there and just enlighten us, if you wouldn't mind.
So I think the first thing is what is the WTO, and also what isn't the WTO. The WTO is obviously a long-standing international trade organisation, but it is, I stress, an international trade international organisation. That's the only thing that it covers in its remit. It is also an organisation that works under consensus. So it's all the members coming together and agreeing things together relating to international trade, most significantly in trade in goods. What it isn't is all the other things that the UK, as a member of the EU, had a shared relationship with the other member states. So when you look at the actual withdrawal agreement, as an example, to see what does it cover, you realise a big chunk of that, for example, is on citizens' rights, is on qualifications and the recognition of them across all of the member states, is on protections with social security, is on judicial arrangements and all of that. So none of that is covered from a WTO perspective. So then if we're only looking at the trade in goods, border, hard, soft, something that's done at the point of entry, something that's done in your site, there is a border. There are customs requirements, there are standards requirements that you may or may not have to meet, there are tariffs, even if they are at zero. And so all of that creates new challenges for EU 27 UK trade. All of a sudden, it means that for all those people who've enjoyed the 44-ish% UK trade that goes with the EU, is all of a sudden you're going to have to become aware of things that you never thought out before. Do I have things like the authorizations from a customs authority? Do I even know what a customs authority is? Do I have something called a customs broker? Why do I need one of those? Do I rely on just-in-time movements for anything that I am purchasing or anything that I am selling? All of that means that you have to get to know your business in a way that is completely and utterly alien to many of the businesses in the UK and also in the other member states that work together. All of a sudden, something that seemed immaterial because you are focused on building something or designing something, they're actually bits of the business that you are going to have to focus on in the event that on the 29th, we have no deal, no arrangements, no mutual recognition, none of the other things that there are between the UK and the EU. So this is a burden because international trade is a very unique, separate thing that happens, but not that many people and many businesses, particularly senior leaders in businesses, have been aware of over the last few decades because of the UK's membership of the single market and the customs union. So yes, there are many reasons why people believe that the WTO is only trading on WTO terms, rather, is not something that is an additional burden, but it is absolutely for all of those companies who have really only been trading in the actual European Union between the member states. And it means that trade, if you've been doing it with the US or with China, doesn't change in principle. Your whole supply chain will change, and there are things that you have to become aware of.
Okay, excellent. So what's the sorts of changes that we might see for, if we're, for example, looking at sort of construction manufacturers? You mentioned there, some of the terms around things like a customs broker. Now, obviously, a lot of construction products trade is just between ourselves and Europe. So, could you just outline what is a customs broker? Why might you need one if we do end up in this sort of slightly different trading arrangement?
Yeah, so I guess if you imagine it a bit like you yourself, you decide that you are going to travel over to France. So you buy a ticket, whether it's for the Eurostar or, it's with an airline. So you're informing not just the provider of the actual mode of transport that you want to go from A to B, but you're also actually telling the government that you're going from A to B. And the same thing is what has to happen with goods. You have to say to the country, in this case the UK, that you're leaving, oh, by the way, I'm taking my construction materials out of the UK. Is that okay? It is basically what it is. And that's a customs declaration that you have to make. As well as that, to be very technical, there's something called a safety and security bit, which is to say, does the government believe that item that is leaving the UK is something that is okay to leave it? That has to be done way before you get to the border to leave the United Kingdom. So that is done by most companies through something called a customs broker. You provide them with the data, they input it through the systems, that electronically goes to customs does its check, and an electronic message comes back, yes, that's fine in 90% of cases, and away you can go. So you can leave the UK, but then you want to enter into France or Germany or Romania. And so an import declaration is also required to say, I'm arriving here, this construction material. Is it okay to bring it in? What's the value of it? Is there any duties that are required to be paid on that? And that is also generally done through a customs broker for the vast majority of people. So those are the kind of end-to-end requirements there, as well as if there are duties, how much is it, import VAT that will need to be paid. And also particularly, I think, something that many may not have considered is my item actually something which is dual use controlled? So anything that has a potential military and civilian use might be on something called the dual use list. In the vast majority of cases, you wouldn't have had to consider that if you're moving those types of goods around between the UK and the other member states. However, you have to consider that now because there is a differentiation between the UK and the member states. And again, that's something that you have to do via an authority, and if a license is required, it does take weeks, sometimes months, to have that process gone through before you can think about moving your goods.
Thank you. That was very comprehensive, and I guess the takeaway, if I'm thinking specifically now for ACE members, actually, is maybe getting to know your extended supply chain. So if you are thinking of specifying, if you are thinking of designing with certain products, it's probably worth working even more closely with the contractor, with some of the manufacturers, to understand what might be available, what might be impacted. So there's something in that certainly to think about. So that was excellent, really helpful in terms of goods. So just turning to our final panelists, and as a quick reminder, please keep sending your questions in. We will do them shortly after Will has spoken to us in terms of what Brexit might mean from a legal contractual perspective. So we will look at this, purely through the lens of contracts you might already be signed up to, but also if you're entering into contracts, actually how might you start to think about some of the risks and the uncertainty in those contractual terms that you would be signing up to going forward. So we've got two aspects to this. So Will has also got a presentation for us, so you should be able to now see that on the screen. Will, let's hear from you.
Thank you, Hannah. So no matter what the Brexit outcome, I think there are broadly two risks which must be when entering into a contract or when looking at the contract that you've currently got. That's the risk of laws changing when we leave the EU, assuming we do, and the risk of uncertainty and the consequences of this process. It's still really difficult from a legal point of view, what the post-Brexit landscape is going to look like. So dealing with these two items, the risks of laws changing. Some standard forms and most bespoke contracts require the consultant, the contractor, the supplier to comply with all statutory requirements. But at this point in time, it's still quite difficult to know what laws will change, if any. In extreme circumstances, Brexit could result in all laws which have derived from the EU being repealed. I should say, we, Beale & Company, think this is very unlikely. It's probable that many of the UK's laws and many aspects of the trading position between the UK and the EU will remain unchanged, frankly because the UK law needs to remain aligned with EU law to facilitate trade, or because UK law, the UK law in question is not derived from the EU law. We've also got the European Union Withdrawal Act 2018, which plans on exit day to convert into UK law most of the EU law applicable immediately before exit day. So the risk of change in law is probably quite small, but there does remain an element of uncertainty and therefore an element of risk. So if you're required to comply with the law in accordance with your agreement, unless it's specifically mentioned in a variation or change of law provision, the consultant, contractor, supplier will be taking the risk of that change in law. So if you're required to carry out additional work because the law changes, this is going to be at your cost. Different standard forms provide consultants and contractors with different protections, and the extent of that protection does vary depending on the contract and the drafting in question. Just by way of example, the NEC forms, they have an option X2, which provides that if there is a change in law, this will be a compensation event, which is fantastic. The JCT 2016 suite, the change of law provisions tend to be drafted so that they provide remedies only if the legislative changes have an impact on the design and construction of the works, but they're still drafting, dealing with change in law, which is a positive. Bespoke contracts, they obviously vary. The change in law provisions usually entitle you to additional time and money in the event of an unforeseeable change in law. Now, it's not clear how this is actually going to be applied in respect of Brexit, because Brexit is obviously foreseeable, but the specifics, the consequences aren't. Slightly away from contracts, another area to consider in relation to the change of law risk, if I can describe it that way, is if your client is a registered company in Europe, let's say a developer or another developer in a member state, and you need to enforce a judgment, say for outstanding fees against that company. At present, UK judgments are automatically enforced in Europe, but this may change after Brexit. The EU has stated earlier this month that EU rules on the recognition and enforcement of judgments will not apply to the UK post-Brexit, and each member state will have to apply their own national rules on enforcement of foreign judgments. So we think this is going to mean that enforcement is going to become more expensive, more time-consuming, and in some circumstances more difficult. And then the second big picture risk that I mentioned is just the real uncertainty, the macro issues, what is going to happen post Brexit. We've heard a lot, many business leaders in the construction sector have expressed real concern. Is there going to be a hit to business confidence? Are clients going to delay making investment decisions? Is there going to be a downturn? Sorry for these negative points. Is there going to be a restriction on the free movement of people and the removal of the mutual recognition of qualifications? And if so, yeah, that could have a real impact on resources in what some regard as an already depleted sector. And another example is importers and exporters may face duties or limits on quantities and other challenges, as we've heard, leading to shortage or delay in materials and other increasing costs. So what we're saying, given these concerns, is that you need to future-proof your agreements to deal with these risks. Contracts might become loss-making or more difficult to perform, but parties to that contract are unlikely to obtain relief from the consequences unless there are express contractual provisions dealing with the risks arising. The fact that there's economic hardship suffered is not sufficient to claim more money, more time, or to exit the contract. And some of you will be aware of force majeure provisions in contracts. It's not a term, force majeure, that's got a precise meaning under English law. And the term is usually defined in your contract as being a circumstance where obligations become impossible to perform because of, let's say, an unforeseen event. But projects are unlikely to be possible following Brexit, and Brexit itself is certainly foreseeable. So we feel that the force majeure clauses are also unlikely to rescue you. So the best way to future-proof against Brexit is to ensure that your contracts deal with the events arising.
Okay, that's excellent, very detailed. Thank you very much. So I'm going to ask a question just because I'm interested on that front. So we've said Brexit is not a force majeure. What would make it such on an individual contract? So, are there any conditions within which it would be actually, if you are getting to a situation where it is sort of business viability? There's a different question really about culturally whether a client would enforce that, but legally, where would you stand if it was such that you were tied into a contract that was effectively given? Certainly some of our sector have very low margins. What would be the legal perspective on that?
So I think if you're a client or a funder on a project, you're going to certainly insist that in your contract you have a right to exit should conditions change significantly, for example. So termination at will clause, and they're fairly typical in the public sector. If you are a consultant contractor, you're highly likely to have a right to non-payment under the Construction Act. Financial position under the project significantly changes, such as the funding dries up. But what we're saying is that clients, consultants, contractors much further than that, not rely on those exit suspension rights. But should include provisions dealing with specific concerns relating to their business. So that might be a variation provision entitling you to additional fees in the event that a change in law impacts your works. That might be drafting allowing for price escalation and currency fluctuation. So again, additional fees and adjustment to your fee to deal with those circumstances. I think most lawyers by now will hopefully have a precedent bank of such clauses, given that Brexit's been on the scene for quite a while. But what we're seeing more and more of is Brexit clause. And this is effectively a widely drafted clause dealing with many circumstances arising out of Brexit. We usually see these on the bigger projects. Include triggers that allow the party performing the contract to get relief or additional fees, and in extreme circumstances to terminate because the triggers cause hardship or impossibility under the contract. So just by way of example, as I said, if further work's required because of a change in law, trade tariffs on goods, or there's a material change in currency exchange rates, drafting can be added to the contract to allow for an adjustment to the price. If there's delay in progress because of border delays or the difficulty in moving staff, you might want relief against the programme and loss and expense because of that. A loss of licence or other major consequence might even be a trigger for termination. But these Brexit clauses can be quite extensive. In short, they should be drafted to reflect the particular risks for your business for that project that may arise out of Brexit.
Okay. No, that's really helpful. Thank you, Will. And I should say, and I can say this as not a lawyer, I'm not putting you on the spot, but so just as probably for information for those on the webinar, earlier this week, the Construction Leadership Council hosted a conference where we started to unpick certain things here. So taking it outside of a legal context, but what they were having quite mature conversations around were actually how do you get that client supply chain interface, moving and working where we do have perhaps changing goalposts on both sides in terms of the funding coming through the clients, but equally some of the freedoms and abilities of the supply chain to fulfill their contracts and their contract obligations to a certain budget. And actually it was quite a mature conversation because with the best will in the world, Will, we're hoping we don't need to deploy you. So that those conversations have started. At a sort of industry-wide level, which is refreshing. And again, a sort of second aspect to that is the fact that the Construction Leadership Council are actively working on this sort of live risk register. And as you can imagine, when we move between varying options, you'll have certain risks that will appear more likely and less likely. And it's just making sure that we are keeping on top of that in a sort of very live sense as we get some more certainty around where we might end up. So again, I think it's useful to know the contractual background as well, but rest assured there are those sorts of conversations happening. We shall see. It could be the greatest act of client and industry collaboration if we can actually navigate our way through the changing environments. So we've had a few questions on the WTO rules around services. Now, I know this is a really complex area, and it is something that we are going to look at looking into in more detail for ACE members, recognising that actually, unless we end with no deal in the short term, it's not something that we're going to be likely to grapple with. As I said, we will be taking this offline in terms of more detailed guidance, but at a very, very basic level, what are the differences between goods and services and how they're treated in terms of WTO rules?
So as I said before, the WTO really grew from wanting to make the movement of goods between countries much easier because, of course, up until the last 20 odd years, it's really been the trade in goods which has underpinned that kind of international side of countries and companies as opposed to services, which has just grown so much in the last few decades. But I think from a pure UK EU perspective, the thing to highlight is the fact that the UK will be outside of the single market for services in the EU, which means that there will be new restrictions for providing many of the services that people may do from the UK into the member states. So, for example, I think one of the easy ones to look at first, particularly from an individual company's perspective, is do you now need to have certain licenses, and has it been lost, the mutual recognition of professional qualifications? So that's something that, you know, it might be we taking it for granted that, for example, someone with a legal qualification in from Germany is licensed in some ways to work within the United Kingdom. So that might be one of the very immediate issues that an individual company will face. Also, another thing is that with the single market in services, it's been that a UK company has actually been able to operate in the other member states without needing to be set up there or registered there. And again, that is something that will go automatically once we leave that single market.
That's great, thank you. And like I said, this is an area where we're going to certainly be putting out more in-depth guidance as we work up the details of some of the more nuanced implications for our consultancy firms and those providing services overseas. So, Will, I have a question for yourself. So this is a question in relation to IP protection and some of the legislation around that to be affected. So the question specifically is there an increased risk from IP protection or enforcement? Is that environment likely to change from a legal perspective? So you've mentioned a little bit already around claims, you know, contractually, if you're working with developers overseas, are we likely to see the same thing around IP?
So much of the UK law or English law on IP protection, I think is English law, and generated here and not from the EU. So I think if there was an IP infringement, for example, here, the decision would be decided here under English law, and then it would be a case of can you enforce that decision abroad. In terms of whether there's legislation between us and member states, I don't know the answer to that, but I expect that that's going to be up in the air, and on that list to resolve if it does exist in the wider discussions around Brexit.
Great, thank you, Will. That was really helpful. So I've got one which I'm going to put to the whole panel now. Actually, it's I think should be relatively simple for Siobhan and Will, but I'd like a political view from Geoffrey as well, and perhaps Julian. So this is in relation to a consultant who might be who is based in Northern Ireland, but working on projects in the Republic of Ireland. So I'd like some factual answers on actually in the event of a no deal, what would that mean? So it may be a simple, yes, it means everything that we've just discussed. But also then I'll come to you, Geoffrey, for your views on politically, actually knowing how intertwined the markets are there, particularly where there are at the moment, you know, some really big infrastructure investments happening within Ireland, but, you know, taking advantage of the expertise from Northern Ireland. Do you think to be a factor that comes into our sort of political negotiations, given that it's, you know, perhaps in the interest of both governments? So factually, would it make a difference potentially on day one of a no deal if you were a consultant working in Northern Ireland but on a project in the Republic? Siobhan?
I'm going to hedge and say yes and no, because I don't know enough facts about this consultant. So it might be that actually the work they are doing, that there will be no change for them. It's just the same way as if you're working on a project for the United States or for China, picking one, you know, two that are normally more contentious with that type of thing. It's just you doing your job wherever you're located. Of course, if it's something to do with relying on your qualifications and you are operating under that and they are no longer recognised, for example, that might be an issue. If there is anything, this is where I guess it becomes a bit more legal in terms of payment, and all of a sudden there's those kinds of issues that rise, then yes. But in terms of just doing your job, I would say the presumption would be no.
Okay, great. So Will, what's your advice?
Yeah, I'd probably almost repeat what has just been said. Of course, UK consultants are working across the globe and have had great success in doing that. We have a Dublin office, and I'm fully aware of the link between Northern Ireland and Ireland, particularly with consultants. So from a contractual perspective, I can't think of anything of significance. The main concern that I had is the mutual recognition of qualifications, and if it's an architect, for example, if it's an engineer, what effect is that going to have on signing of drawings and etc. etc.
Okay, right. And Geoffrey, how might this feature or factor into some of the negotiations that are ongoing?
Well, look, I think the relationship between the Republic of Ireland and Britain is not going well at the moment, compared to what was actually a golden era following the Good Friday Agreement, and I think that's very sad, and that could get worse in the next few weeks in terms of resolving this. So that's one negative thing I'd say, that the broad relationship is not great, and could get worse. However, the Irish, there's two things to bear in mind. First of all, we still have the common travel area. Whatever happens, even with a no deal Brexit, the common travel area will remain, which gives rights to travel and reside between Ireland and the United Kingdom, and very generous rights, particularly for people from the Republic of Ireland living here. So that's not going to change. I think the second good thing I'd say is, well, actually, the other thing, and it depends who you are, because my daughters have forced me into this, where I wouldn't naturally do it. You can get an Irish passport. If you're born in Northern Ireland, or your grandparents come from Northern Ireland, you can stay in the EU by going off and being a dual national and getting an Irish passport. And I know at least 40% of the population will find that difficult, but that's another option to help in terms of doing business in the South. One thing I'd say is, I think that we have to remember the reason the South is taking quite a hard line on the withdrawal agreement and the backstop is because it sees that as a support, not only to the peace process, but to the people of Northern Ireland. You can debate whether they got that right, but I'm sure that that is their intention. So the one thing they will see after any incidents of a no-deal Brexit is they will seek to keep the economic ties between North and South as open as possible. And in fact, you heard a little bit earlier some of the reflection of that, in that the Irish government has already said they don't want a hard border, but they may be forced by Europe to impose extra border checks, but that's not something they really want to do. So my view is there'll not be a problem in practice in doing business in the South from the North. We'll seek to be extremely generous within the rules available to those who want to do business from Northern Ireland. And you've got some other things that will underpin that.
Okay, excellent. Thank you, Geoffrey. Julian, did you have anything to add to that, or is that comprehensive enough for you, do you think?
No, I absolutely broadly accept that. I think the only way there would be a problem for firms in Northern Ireland is if we crash out with no deal. But the symbolic issue for both the UK government, the Irish government, and the European Union of destroying the concept of Ireland as an economic whole would be tremendous, and I think many ways will be found to actually ensure that kind of trade continues across the border, particularly in services.
Great. So we've got a question back on WTO rules, and this would be, I should put this to Siobhan, and then I'd like to ask Geoffrey's view on whether he thinks the government are doing this. So Siobhan, from a practical perspective, if there is a no deal, what are the actual steps the UK government would need to take to have their own trade schedules within WTO, so not following the EU schedules? And is that, if you could just talk us through what the process would be there, and then Geoffrey, I'd like to to see if you could perhaps give us an indication about whether you think those things are likely to be happening.
Well, that's sort of kind of, I guess, how we would both be answering one and the same, because the UK has already actually put forward their tariff schedule to the WTO. So that was one of the very first independent trade moves done by the Department of International Trade. They have done so based on the EU schedule in order to avoid any potential conflict and hopefully to smooth that passage through. And they have done it with the support of the EU as well. So it has been one area where I think we've had clear collaboration between the Commission and the UK from a trade perspective. How well that's going, I will now hand over.
Okay, no, that's really helpful. And I guess, I mean, presumably in future they could go back and, you know, at the moment, if they are broadly in line with EU schedules, actually, if the UK government does want to go back and revise them, presumably that's just another process that we would enter into.
It is, but the thing again, going back to the underpinnings of the WTO, it's a consensus organisation. So you can't just turn up and say, this is my schedule, I would like to get it registered. And unfortunately, it is then the other members get to say, well, let's have a little look at this and see if we agree, particularly because it's not just about what your tariff rates are. There's also quota lists in there and all of it. So if for any reason, and bearing in mind that the WTO has not been the most dynamic of organisations in the last decade or so, as we are still in negotiations of the Doha Round from 2001, I think is when it started. And there have been many individual issues with certain members of not wanting to concede in an area of particular importance to them. So there is no reason to presume that everything will just sail through, particularly if the UK was looking to create a new, very different schedule, which some of the members would find contentious.
Okay, great, thank you. That was really useful. So, Geoffrey, and we're seeing Dr. Liam Fox on various trips around the world at the moment. I mean, what the UK government's appetite and how prepared it is to start to vary, you know, potentially some of these WTO schedules?
Well, I think they're at the moment their primary focus and efforts are going into taking the existing trade deals that have been done with European counterparties around the world, actually getting those adopted as UK trade agreements. In accordance with Europe, you know, the terms which you agree with Europe, and they're finding it difficult because naturally enough, some of those countries regard it as an opportunity to have a negotiation over those terms again. I think there's some progress being made, but that is their first priority, is to get those existing trade agreements, which Europe has benefited from, into the name of the United Kingdom going forward, and that's their first priority. Obviously, they do want to do trade agreements after that. There will, you know, if there is a deal, there is quite a long negotiation and a detailed and difficult negotiation to go on a trade agreement with Europe. And in fact, I mean, those who are party to this will say that's going to be more difficult than what we're negotiating now in terms of a withdrawal agreement. And that's largely because every country has got a very particular interest of the 27, and they will have to agree to the end to that. I mean, they're looking at other trade agreements. You know, there's Commonwealth countries who are keen to do trade agreements with us. The United States will be keen to do a trade agreement with us. But the way the US works is basically you take it or leave it. So, you know, that would mean a sort of move towards being aligned to their systems, their standards. And I know that people see that as quite a difficult thing to deliver within the administration. So, so what I think we can see and hope for is, in the short term, the UK will adopt the European treaties with other countries, but in our name. hopefully largely intact in terms of what was originally agreed, and a longer term process of putting in place a wider range of trade agreements, which I'm sure will happen, but I think we have to be realistic as to how long it's likely to happen. Mm-hmm. And I know, certainly civil servants involved don't think it's going to be that quick.
Okay, excellent. Thank you very much. Right, so our final question is for Will. So back to our scenario with our consultant who is based in Northern Ireland, mm-hmm. but working on a project in the Republic of Ireland. Mm-hmm. So should we end up where we are in sort of different places in terms of our taxes and our tariffs, would there be a risk that under the terms of the contract, are they likely to be able to claim some of those taxes and tariffs that would come into force part of the way through the contract? So this is we end up where there are additional taxes and tariffs due because there are different rules, I suppose, to put it simply. Would they be able to claim those under the terms of an existing contract? So
it's a classic lawyer response. It depends, and it will depend on the appointment, I think. And it will depend on the fee schedule. It will depend on how the fee is described and what is included in the description of the fee. Just as you might say, and this is my view, just as you might say the fee is X plus VAT. I think consultant in question and other consultants, where there is a risk, should be saying in their contract, our fee is X plus X and Y should the event arise, and at least have a discussion with their client when entering into the contract about who is taking the risk and the cost for that potential additional fee or cost. I think if it's a live contract now and it's just silent on the issue, again, it will depend on what the contract says. There's sometimes clauses that state the fee shall be inclusive of all taxes, duties, etc., etc. And if there is a clause to that effect in the contract, then the straight answer is highly likely it's no. They won't be able to claim for it. So it depends on the contract. I think it's unlikely they will be able to claim for it, and it's a risk that will sit with the consultant.
Okay, great.
Can I just add something that particularly I think that hasn't had a good focus for intra-EU movements of goods and supply purchasing agreements is check your Incoterms. That is really what determines contractually who's responsible for import and export, who's responsible for the duties to be paid. So there are many times where what is written down in the Incoterm isn't actually what is happening operationally on a day-to-day basis. So it may be a case that company X, the buyer or the seller, whichever way around, is paying for something that according to the Incoterm they shouldn't, or vice versa. So really go back to basics, know your supply chain, know your Incoterms, know contractually who's responsible for what.
Okay, and this is we do have the ACA Helpline who may be able to take specific queries on things like these contract terms. So that would be worth, if you want to take advantage of that, digging out your specific contracts and any individual questions that you might need to ask on that. Certainly you would have that as a benefit, so please make sure you are utilising that where you have a specific term, but obviously helpful to get the most out of it, get your contract out and have it there so you can get a sort of black and white answer from our legal team. Okay, so I think in terms of questions we're going to stop there. So I know there are more questions than we've been able to get through, but as before we'll collect those up. We will put them to our panel offline and ask them to draft us some answers and some and we will then upload that into our frequently asked questions document, which is growing by the day. So I suspect it may become a frequently asked questions thesaurus. It's going to be huge. It's going to be about Brexit. So please keep sending those in if you think of anything else that you would like us to answer, and also suggestions for future topics. So we've done these now on a few different topics. We are series. Again, please feel free to nominate some topics that would be of interest where you would like us to get an expert on our panel for those. So other than to say thank you very much for my panelists today. Fantastic, really insightful, really detailed, useful knowledge we've been able to share. And thank you to all of you who have I hope it has been useful. You can listen again just to make sure you've absolutely understood the ins and outs of the WTA rules. If you have time. Other than to say, I shall expect to be back here perhaps in a couple of weeks' time. Please do join us again, and please do keep in touch if you want advice, guidance, and to suggest us some future topics. Thank you very much all.